Hi there. My name is Rainey Reitman, and I'm with the Electronic Frontier Foundation. And the mic is working now, so I'm going to jump right into it because I stupidly thought I had an hour-and-a-half long talk, and I don't. So we're going to move a little quicker. So today I'm going to talk about the politics of surveillance. And before I jump into all of that, I thought I would explain who the Electronic Frontier Foundation is and who I am. EFF is a nonprofit civil liberties law firm and advocacy center. We're based in San Francisco, California, and for more than 20 years now, we have been defending civil liberties on the internet. We started out as a sort of hacker defense fund, and now we've moved into all sorts of different areas. And my particular job at EFF is the Activism Center. So we are the people who are rallying the troops to fight back against bad legislation. We worked hard to fight SOPA and PIPA, and we run the blogs, and we do a lot of the outreach and a lot of the legislation, especially in the United States. So a lot of my experience is specifically working with staffers and policymakers and people on the Hill and grassroots activists to try to make legislation that will respect people's liberty. So, a little bit of history. Back in 2005, EFF had a visitor to our offices, an individual who showed up with a huge stack of papers. He said that he was a former AT&T technician and that he had evidence that AT&T was siphoning off a copy of every piece of internet traffic and sending it to the National Security Agency. That individual turned out to be telling the truth, and we were able to take the evidence that he provided us, that whistleblower evidence, and start 2 lawsuits. The first person we sued was AT&T for their assistance in the government in dragnet surveillance of internet users. And we also then sued the National Security Agency. This photograph here is of a room in San Francisco, the Folsom Street facility of AT&T. You'll see the bolts are on the inside of the door. It doesn't have any handles. That is the room where the NSA set up their fiber optic splitter to send traffic and data, copies of it, wholesale to their facilities. So that is how we came to sort of get up to our necks in fighting the National Security Agency on dragnet surveillance. We're still involved in those lawsuits, and I'm going to talk a little bit more about them in a second. But before I get into all of that, I wanted to talk about how America makes its laws. America makes its laws in 2 ways. America makes its laws by Congress enacting legislation. So for example, you have one body of the House will pass a bill, the Senate will agree on the bill, the president signs it into law, that's your law. Most people are very familiar with this. The other way that America makes its legislation is through court proceedings. America's courts have a very significant role in interpreting whether the law should stand, whether the law should be struck down, whether it's constitutional, how the government is able to implement the law. Which means that when we're fighting against the NSA, we're fighting on these 2 different battlegrounds. We're in the courtrooms, and we're also fighting in the legislature. So today, I'm going to talk a little bit about all these leaks that came out most recently. In fact, I don't even think I'm going to touch on them all. I'm just going to touch on a few of them. And then I'm going to talk about what are the actual mechanisms that would be necessary to stop the National Security Agency from this kind of spying. Like, what would we have to do in Washington, and what would we actually have to what kind of changes would we have to force there? And if not in Washington, then what would we have to do in the courtrooms? And I'm going to specifically talk a little bit about EFF's lawsuits in this area and the activism campaigns we are rolling out to try to push these things along and get them national attention. So most people probably noticed the Fisk order that was published by The Guardian. This was the order to Verizon business customers that required them to provide on an ongoing daily basis information about all of their business customers. It was metadata, so it was information like who you're calling, how often you're calling, how long those calls are, things like that. This order was, according to Dianne Feinstein, the same order, the same 3-month order that the Foreign Intelligence Surveillance Court is issuing every single 3 months. And they have been doing it for the past 7 years. The Wall Street Journal has come out and said that this is identical to the types of orders that AT&T and Sprint also have. So who is this court that is issuing this order? The Foreign Intelligence Surveillance Court got started in 1978. It was a response to domestic surveillance scandals. It was actually an attempt to put more control and more oversight into the United States domestic surveillance programs. It's a secret court, and it oversees all of the federal government's applications to conduct surveillance around national security issues. So this is actually like a secret court in the sense of you can't even get into it. You can't even find the mailing address for it. EFF recently tried to file in the court, and we had to just call a phone number and leave a message and hope that somebody listened to the message eventually, like, hey, this is EFF. We want to sue the government. Is this the right avenue to do it? And so they generally, most of the time, the people in this courtroom is just the judge and the government gives their argument, the judge decides what they think, and then what those arguments were and what those decisions were are entirely secret. So I remember I talked earlier about how America makes its laws, and one of the ways it makes its laws is because the courts have a process of interpreting the law. What we have here under the Foreign Intelligence Surveillance Court is a secret court, and through its decisions, it is making secret laws. So these are laws that are governing the United States that the American people really don't have a lot of insight into. And it was one of these court decisions that resulted in the Verizon order getting approved. The EFF has been seeking access to some of those documents. I'll talk about that in a little bit. I do want to also point out that the government doesn't always get approval from the secret court. On at least one occasion, the types of surveillance it was engaged in was found to be unconstitutional, violation of the Fourth Amendment, the rights to privacy that individuals have in the United States against government surveillance. So the other interesting thing I wanted to bring into this to help you guys understand that FISC order is Section 215 of the Patriot Act. Section 215 of the Patriot Act is a very poorly understood portion of the Patriot Act. It's a very much abused section of the Patriot Act. It's considered the business records section. And the idea is that, well, to back up, before the 9/11 attacks, this sort of authority allowed the government to get access to storage rental records, hotel rental records, car rental records, and then some metadata on telephones. But they had to have the specific and articulable facts that led them to believe that it was related to a foreign intelligence investigation. After 9/11, the language for this kind of authority became far, far looser. All of a sudden, the government merely had to, was able to ask for any tangible thing. Any tangible thing could be requested under this authority, Section 215 of the Patriot Act. It had to be relevant to an authorized investigation to obtain foreign intelligence information not concerning a U.S. person or to protect against international terrorism or clandestine intelligence activities. So tangible things, something you can touch, relevant to an authorized investigation. So those are the two standards you have to meet under 215. Now, what was the Verizon order? The Verizon order was an ongoing, on a daily basis, for all phone calls made, even in the future, of every person using Verizon business services. So first of all, just how tangible is that? How tangible are these records? They're certainly not something you could hold in your hand. And second of all, how could the government be saying that every single phone call made by a Verizon business customer was relevant to an authorized investigation? even phone calls that hadn't yet been made, because it's a daily basis, so it's going forward. So that is the legal landscape that allowed, or that constitutes the Verizon order that came out with The Guardian. And I'm going to talk a whole bunch more about sort of how we fight back against that sort of thing. But I wanted to quickly go through some of the other leaks that came out and what we know about them. I'm sure most people in this room are already familiar with PRISM. It was a leak by The Guardian and The Washington Post that indicated that internet and telecommunications companies in the United States were directly working with the government to allow for data to be swept up and handed over to them. There have been a lot of disputes about exactly how this is happening. And do they have direct access? Do they have direct access to the servers, et cetera, et cetera? I don't want to get into those disputes. I would just say that it's quite likely that the system that the National Security Agency sets up with one company might not be identical to the system that they set up with another company. And I don't think we should get so tied up in those disputes that we can't talk about the real major issue, which is that they're getting so much sensitive information about everybody's daily internet usage. It began in 2001, and the legal instrument, the law, that they're using to try and justify this is the FISA Amendments Act. I fought the FISA Amendments Act reauthorization last December, and I'm very sad to say that I was unable to stop it and unable to get a single piece of privacy protections put into place. But I will talk a little bit more about the FISA Amendments Act in a second. One of the other things that came out as a result of the leaks in The Guardian and The Washington Post were internal procedures by the NSA. They published two documents. One was a document of the procedures that the NSA uses to target non-US persons. And then the second document was procedures that the NSA uses to minimize the data they collect on US persons. And as probably some of you read, they were pretty lax in their understanding of what was and wasn't a US person. And then once they had collected all that data, they had a very loose minimization procedures in place to remove the information they weren't directly targeting. So one of the things that the National Security Agency can say is, well, our filtering system wasn't working very well, and so we accidentally collected too much information, and so now we've got it, so that's one of the standards by which we're arguing we can maintain it. Our filtering system wasn't working. Or maybe in collecting all this information, they bumped into information about criminal activity, and then they wouldn't want to get rid of it. And then maybe the information was encrypted. And if the information is encrypted, even if it's not a US person, then they still want to just hang on to it, because everybody knows that if it's encrypted, who knows what could be in there. They also say that we'll hang on to information for traffic analysis, a very specific thing there, traffic analysis, and then also foreign intelligence information. That the way they define foreign intelligence information includes private communications between someone and their attorney. And in the United States, we have a very, very high legal standard that protects the privacy of communications between you and your attorney. And so that's pretty concerning. Tempora is another interesting leak that just came out. It is the British government's mechanism of tapping transatlantic cables. They have 200 different probes where the cables come ashore, and they're able to get phone and internet content, not just metadata, but content, and they hang on to that content for 3 days, and they hang on to the metadata for 30 days, and then they hand it over to their friends at the National Security Agency. They have hundreds of people working to go through all of this information that they're collecting. The UK is defending the program. The Foreign Secretary said, in both our countries, intelligence takes place within a strong legal framework. We operate under rule of law and we are accountable for it. In some countries, secret intelligence is used to control their people. In ours, it only exists to protect their freedoms. And then the last thing I wanted to mention, and I haven't delved as much into this one, but it's getting a lot of attention, is recent revelations about the United States using Cold War spy tactics to collect information on other embassies. They're using bugs that they implant on electronic communications gear, they're intercepting their faxes, they're tapping into their wires, and they're using these special antennae to collect all their communications. And what they're doing, what it seems to be the main target of the United States collection of this information, is finding out where different countries are in regards to different trade agreements. The United States is involved in a whole bunch of different trade agreements. Overwhelmingly, these things are negotiated behind closed doors without the public's ability to weigh in on them. And yet, it seems that for all the secrecy that the United States insists on having in these trade agreements, they are nonetheless snooping around and trying to get a whole bunch of information from other people involved. So, the rest of this talk is going to be about what we're doing about all of this. And I just want to also say that, obviously there's a whole bunch more detail about the leaks that came out. There's probably more that we're going to know as we analyze it going forward. But I didn't want to spend as much time talking about what's come out so much as what we are doing. Like, what's our strategy? What can we do to actually stop this kind of thing? Our goal is to stop this type of spying, that dragnet surveillance on people who are not accused or even suspected of any crime shouldn't be allowed. And we have a few different things that we're doing to try and do this. We have lawsuits, which I'm going to talk about. As I mentioned before, lawsuits are one of the major ways that you can change law in the United States, that you can affect major change. We have advocacy at Congress, which is where I spend most of my time. And I'm going to talk about sort of how that's going. We have kind of a few different things we're trying to get Congress to do. And the first thing, the most important thing, is to push them to have more transparency around domestic spying and spying in general. The more we know about what's going on, the easier it is for us to use that information in our lawsuits, and the easier it is for us to write laws that will prevent them from doing it in the future. We're also seeing increasingly the power of international pressure, so different countries pressuring the United States to answer questions about what's going on, and then technical solutions. So I'm not going to talk about technical solutions because we could give like a 2-hour talk about technical solutions for protecting yourself online. And probably a lot of you would give that talk better than I would. I will point out 2 resources. One of the organizations I work with is called the Freedom of the Press Foundation. I helped found it last December. We just released a white paper, so it's pressfreedomfoundation.org, which is a guide for people trying to use free software to protect themselves from NSA surveillance, specifically if they're journalists trying to talk to sources. And second thing I want to point out is Surveillance Self-Defense, which is a guide that EFF put out quite a while ago. And it has a ton of really thoughtful, useful ideas about what strategies, based on who your adversary is and what their techniques are, what you can do to protect yourself. So that's ssd.eff.org, Surveillance Self-Defense. I will say that surveillance self-defense is a little bit out of date, and so I think, especially now, it'd be very good for us to go back and revise that. So, setting technical fixes aside, what are we doing about this as far as law and policy goes? So these are some lawyers at EFF. That's Mark, Kurt, Cindy, Matt, and Nate. This is actually them outside of a courtroom right after we had national security letters declared unconstitutional earlier this year. And these guys are pursuing a number of lawsuits to try to stop the National Security Agency from engaging in this type of surveillance. I mentioned them a little bit before. The first one we launched was against AT&T. It was Hepting versus AT&T. We launched it in 2006. That lawsuit has bumped into a few sort of roadblocks. The first was the FISA Amendments Act. The FISA Amendments Act was passed, I think in 2008, to try to give the companies that participated, that helped the government in surveilling people, retroactive immunity, so that it would be more difficult, much more difficult for us to hold them accountable for their role in surveillance. And then we have still tried to pursue it, but unfortunately the Supreme Court at this point has declined to hear our case, which means we're not getting very far right now with Hepting, but we are moving ahead with Juul. Juul is our case against the National Security Agency, which we've been pursuing for a number of years now. It's a class action lawsuit, and it tries to hold accountable the National Security Agency and a whole bunch of top officials that allowed this kind of surveillance to be put into place after 9/11. Right now, that case has standing, which means that the courts have found that we have a reason to continue forward, and we're able to move ahead with the case. The major legal instrument that the government has used to stop our case from moving forward is the state secrets privilege. They say, well, we can't talk about what's going on with surveillance because it's a state secret and it's super classified and we're not supposed to get into it, so sorry. And they keep, every time, no matter what evidence we throw at them and what information, they keep saying, well, it's a state secret. One of the amazing things that is happening right now is that we have all these leaks from Edward Snowden, and we have the government responding, and the government is saying, yes, that's true, we do that. What happens to their state secrets privilege? Are they still going to argue in court that they could say that they can't discuss it because it's a state secret, but then also go on CNN and say, yes, we do that? I don't know. That will be an interesting legal argument. Right now, the government has asked for 30 days to consider its position. So we will see what they come back with. We also have Freedom of Information Act requests. Freedom of Information Act requests allow us to ask the government to provide public data about what they're doing to the public. Overwhelmingly, the Freedom of Information Act in the United States is completely broken. The only way you get any information out of the government is by waiting months, sometimes years, and then taking them to court and suing them for it. That's not the only way, but it's the only way you get any of the really interesting stuff. So I said earlier that there was this Section 215 of the Patriot Act, that you had to have something tangible, you had to have it be relevant to an authorized investigation. And then I said, what's going on with this FISA order that allows the government to get Verizon phone records on an ongoing daily basis? How could they possibly think that's relevant? How could they think it's tangible? Well, somewhere there's a court document that explains what the government's legal argument is, how they're interpreting the law to allow them to do that. We have a FOIA lawsuit where we are trying to seek access to that interpretation of the law, the government's interpretation of the law. It's really, really, really important that we get that, because it's very hard for us to go to Congress and change the law or write a new law in a way that would prevent that from happening unless we understand how they're allowing it to happen right now. So it would be very difficult for us to go and change the law in just a slight way or make adjustments or make an amendment if we haven't got an understanding of how they've interpreted the law as it stands. Right now we're just sort of shooting in the dark because we don't know what legal argument they have in place to allow this to happen. We are also seeking, I mentioned earlier, that there is at least one time that the Foreign Intelligence Surveillance Court found that what the government was doing violated the Constitution, that their minimization procedures for protecting privacy violated the Fourth Amendment. Senator Wyden, who's a great champion of freedom on the internet, forced them to say this sort of publicly. So we are seeking access to that as well. The other thing we're doing is we launched an online campaign. It's at stopwatching.us. Right now we have over 500,000 people who have signed on to it. We have hundreds of organizations all over the world that have signed on to it. We have celebrities, and we have internet companies like Reddit. And with this, and I'll walk through this, but every time somebody signs on to this, it sends a letter. And if they're in the United States, it sends a letter to all their elected officials. And if they're outside of the United States, it sends a letter to Obama. So if you haven't signed it, you can sign it and you can send this letter to Obama. And I'm going to tell you what that letter demands. It demands transparency, a new congressional committee to hold the government accountable for what it's doing. It demands legislative reform to the FISA Amendments Act, to Section 215 of the Patriot Act, so that this isn't allowed to happen anymore. And then it requires that public officials that allow this to happen are held to account. And I just want to reiterate that it is very, very, very difficult to write legislation. So it's very, very difficult to write a law that's going to stop this from happening if we don't understand what the government's interpretation of the law is now. Fukami asked me to talk a bit about the politics of this, so I'm going to actually kind of delve into like the politics of this. So if we need to understand exactly how the government's interpreting the law, and if we need to understand exactly what the surveillance is, we need somebody to get to the bottom of it, to hold hearings, to get people to testify in front of court, to lay it all bare. And that would allow us to both be useful in our lawsuits and also to write laws that would stop this from happening. But we have to have the facts. We have to have transparency. So who can give us that kind of transparency? Well, there's a couple of different entities. There's congressional committees like the Intelligence Committee or the Judiciary Committee. There's the Privacy and Civil Liberties Oversight Board, and then there's this possibility of, well, maybe we can make a new committee. So I'm going to talk a little bit about what's with all of these options and should we be preferring one or the other and what are the drawbacks. So the Intelligence Committee in the Senate was created in 1976, so right around the same time that America was responding to all of these scandals around surveillance. And their job is to oversee and make continuing studies of intelligence activities and programs. They submit proposals for how you can deal with intelligence, and they are supposed to provide vigilant legislative oversight for the intelligence activities of the United States to ensure that such activities are in conformity with the Constitution and the laws of the United States. That sounds awesome, doesn't it? Doesn't it just sound like this is exactly the kind of committee that's going to go out there and ask those hard questions and get some answers and change this? Unfortunately, this is the same committee that meets frequently, very frequently, behind closed doors, and they get briefings from the government that explains all of these things that they can't then tell us later. This is the kind of committee that probably was already briefed on the type of surveillance that was taking place. On this committee, we have two individuals, Mark Udall and Ron Wyden, who are pushing very, very hard to rein in government surveillance and the unconstitutional surveillance. Ron Wyden said, "I want to deliver a warning to you. When the American public finds out how their government has secretly interpreted the Patriot Act, they will be stunned and they will be angry." I would say he is right. We are stunned, we are angry, and so are people well outside of the United States. Leading the Intelligence Committee is Dianne Feinstein. She is someone who's very liberal in many ways, except when it comes to surveillance. When it comes to surveillance, she has stood fast and believed that what we're doing is fine. She has supported Clapper in his statements and supported the system in place. She has said, "I feel I have an obligation to do everything I can to keep this country safe." And she very much controls that committee. It would be difficult to move forward with a powerful oversight hearing without her assistance, and she's unlikely to assist, which means we have to look at other committees, like the Judiciary Committee. I would just say that the Judiciary Committee oversees the Department of Justice generally. Patrick Leahy has considered bills that might be useful in reining in some of the Patriot Act. So we're kind of looking to see, is that a better committee to go for? On the House side, we have a similar situation. You've got your Judiciary Committee and your Intel Committee. The Intelligence Committee on the House side is run by Mike Rogers. He wrote CISPA. He wrote a bill that would have allowed companies to share data with the government with perfect immunity. So we think that he would be a terrible person to try to provide oversight. I hope that what you're getting away with is the sense of like, I don't really see what committee in Congress is going to do this hard work. Like, who's actually going to get to the bottom of it? We're also kind of wondering that. We don't see a champion for the kind of oversight that we're hoping. Obama has his champion. And that's the Privacy and Civil Liberties Oversight Board. That's a really nice name, Privacy and Civil Liberties Oversight Board. These are 5 people appointed by Obama, and they are confirmed by the Senate, and they have an interesting history. They were supposed to go in there and sort of ensure that the government's surveillance programs were not out of whack with civil liberties. But then back in 2007, one of their members resigned and said that the White House was trying to edit their reports and make it impossible for them to speak freely. It was basically dissolved, and so the board has not existed. It's just never had any people on it, it's never had a chairperson on it, it's just been sort of a board that nobody was on. And so it hasn't really done anything in particular. And it just kind of started to have its first meetings right in the middle of this NSA scandal. And Obama said, oh, this is the perfect vehicle for having an informed discussion about this. They don't really have any staff members yet. They are just starting to get their staff members. One of them, their legal counsel, worked for the NSA for 10 years. And they are having their first meeting next week. Next week, they invited all these experts from all over the country to come and testify about what NSA surveillance was and what the law said. They did not invite EFF, which I was interested to see. They met with Obama for the very first time in June. So a lot of people are saying, well, why doesn't the Privacy and Civil Liberties Oversight Board just get to the bottom of all of this stuff and provide you transparency and get you oversight? And I would say it's because the Privacy and Civil Liberties Board has never done anything. It's never done anything at all. So it's a little worrisome to try and hope that this is going to be the body that reins in domestic surveillance. Back in the 70s, we had a church committee. It was a special committee that was formed that did a ton of investigation and put in place some of the oversight that we have now. And there's been this urge, this thing that EFF has really pushed hard for, of the heck with all these committees that exist, they're not going to do anything, let's have a brand new committee, somebody whose sole job it is to rein this in. And what we have heard from people in Washington is that that is politically unfeasible. But we are still, we're still kind of looking at that. I think it's still our best bet. So I said earlier, so the second ask of our petition is for legislative reform, to fix the laws. There's those 3 laws that are problematic: the FISA Amendments Act, the Patriot Act, Section 215, and the state secrets privilege. Setting aside the state secrets privilege for a second, the problem with the Patriot Act is that we don't know how the government is interpreting it. We don't know what their legal arguments are, which makes it very, very, very challenging to change the law in a way that will actually result in the spying stopping. And then the FISA Amendments Act is the legal instrument that they use to allow PRISM. Currently, there are bills dropping that are like, oh, we're going to deal with all of this NSA spying. We're going to enact reform. Here's what we're going to do. Here are our proposals. None of the proposals on the table right now would do anything about PRISM. None of them would do anything about PRISM. The proposals on the table now are dealing with the Patriot Act, not the FISA Amendments Act. And they're trying to deal with the Patriot Act, but you bump into those problems of, we don't know how the Patriot Act is getting interpreted, so how can we actually change it? The proposals currently would raise the standard that the government has to meet in order to get one of these 215 orders. And there are some proposals also to call for more transparency around the FISC courts. And I think we would support those transparency calls. And then there's several different proposals to insert language that says, well, each of the tangible things that you're getting under the Patriot Act would have to be related to a U.S. person or something like that. They're trying to make it more clearly targeted towards people who aren't in the United States. But it's very unclear that they'd even be able to do that if they don't know how the law is currently being interpreted. The third thing we're asking for is that public officials be held accountable. Do you guys know this individual who's been all over Reddit? This is National Intelligence Director James Clapper. Asked a little while ago so General Alexander went to DEF CON, and he got in front of all these hackers and he said, oh, the NSA is not collecting a dossier on every American. We're not collecting dossiers on millions of America. And Wyden went to Congress, Clapper was testifying. He said, I don't know what a dossier is, but can you tell me, is the National Security Agency collecting any information on millions or hundreds of millions of Americans? And Clapper said, no, sir. And Wyden just looked at him confused, like, really, that's what you're saying? And he said, not wittingly. We're not wittingly collecting millions of records. I would say that that was a particularly interesting response because Wyden had sent him the question beforehand. He sent him the question the day before. And then after he gave that response, Wyden gave him an opportunity to change his answer. He said, listen, go on the record and change your answer if that's not the answer you want. And Clapper refused. But very recently, he wrote a letter to Dianne Feinstein and apologized. He said that my answer was clearly erroneous. And he said that he simply didn't think of Section 215. So when they were asking him whether or not the NSA was collecting records on millions of Americans, he just didn't think of that one program where they're collecting records on millions of Americans. He was thinking of something else. So a lot of people have called for his resignation. I think that's really interesting. I'd like to see if that happens. I think that that would send a very, very powerful message to the rest of the intelligence agency. So that's sort of the state of the legislation. I don't want to be negative, but the laws, the proposals on the table right now aren't really going to stop the surveillance that we're worried about. And the committees that are in place don't really have the backbone to go and give us the kind of transparency that we want. So what can we do to actually kind of increase the heat on this, to sort of change the dynamics? So we've been using the Stop Watching Us petition, and that's been getting very big. We have a bunch of celebrities that we're trying to bring in. We're also asking people to go, and this is unfortunately US-based specifically, and meet in person with staff members or call their members of Congress. We're trying to create student activism groups, so get students really engaged on this issue and get them organized. And then some of the groups are actually hiring lobbyists to go work on this. This individual is Mark Perkel. He and I were in San Jose a couple weeks ago listening to Nancy Pelosi speak, and Nancy Pelosi got up and was saying, well, when it comes to surveillance, we got to have a balance between security and privacy and security and civil liberties. And Mark Perkel stood up in this banquet with all these people, and he said, there's no balance, this is unconstitutional. And he said, no secret law, and then he got kicked out by this guy. But it was really powerful. It was really powerful because all of a sudden Nancy Pelosi is having to be on this stage and she's getting yelled at from the audience. She got booed by everybody in the audience for her statements, and she had to deal with it. And I thought that was a really powerful thing. Another thing that happened is a group of students at the University of Wisconsin. I don't know if you guys heard about this. It just happened recently. It was pretty great. So the NSA goes around and does all this recruiting at all these universities in the United States and says, oh, you could work for the NSA, you'd have great benefits, you'd have so many interesting experiences. And the students got extremely angry and said, you're lying to us. What you're talking about isn't true, and why are you targeting our allies in other countries, and why are you engaged in this kind of surveillance? And it went on and on for like 15 minutes, and they recorded the whole thing and they put it on the internet. And so I thought that was amazing, because all of a sudden, when the NSA goes out to meet with their college campuses and do their recruiting, they're getting bombarded by questions. We are also organizing a whole bunch of rallies. July 4th is Independence Day in the United States, the day we celebrate not being a colony. And so there were rallies. This is the rally yesterday in New York. There were over 100 rallies in the United States. This one had over 500 people, so did the one in San Francisco and the one in Washington, D.C., of people saying that the Fourth Amendment prevents dragnet surveillance, prevents the government from siphoning up data on people not suspected of any crime. We also have the Internet Defense League, which is a coalition of websites and companies and organizations that are working together to defend the future of the internet. I am a very proud member of the Internet Defense League Steering Committee. EFF is a proud member of the Internet Defense League, and we had an online protest where we put up a picture of the Fourth Amendment on our websites yesterday. I think there's a lot of room for international pressure. So all over, I don't know if you guys have been sort of seeing the news in the United States, but all over there's all these allegations that these spying allegations are going to sour our trade relationships. It's hitting us in the pocketbook. It's making us lose money because all of our European allies aren't going to want to work with us anymore because we're spying on them. I think that those are fantastic news stories. Those are just the kind of news stories I want to read about. So if there's anything we can do to get more of those news stories out there, I think that would be good. There have been a ton of articles specifically about how concerned Germany is with this kind of domestic spying. I've heard mixed things from the people I've met in Germany about whether or not you guys are satisfied with the position your government is taking on domestic surveillance. However, what's getting reported in the American news is that the Germans are concerned, and I think that's good. We've been working with international advocacy groups to organize public letters. I think there's a lot more that can be done. Is Congress going to listen to international groups? I don't know. I really don't. I really don't know. And I think that's got to be incredibly frustrating because here the United States is spying on people all over the world, and they're completely deaf to everybody's criticisms about it, except for the people that helped to get them elected. So I think that can be changed. It's just going to take a lot of pressure. And I think I'm almost out of time, but we got through that whole thing much faster than I thought we would. I want to end by saying that there's this really cool group, Freedom Not Fear, if you guys are involved with it. And what I like about them is that they get people organized and working on fighting for privacy and fighting against surveillance and saying we don't have to be afraid anymore. And if you're not involved with Freedom Not Fear, check them out. They just picked out their dates for this year and when they're going to be organizing, I think, in Brussels. And so, you know, my concluding statement is that I know that this is really disheartening to see how hard it's going to be to get Congress to change its laws and get them to do transparency. But we have a lot of tools in our toolbox. We've got lawsuits, we've got grassroots activism. We're working hard to push for more transparency and legislative oversight. And it's not going to happen overnight, but I have never seen the kind of coordinated advocacy effort in the United States to push back against surveillance as I have around this. And I think that the more sunlight we shed on this, the more people are going to be upset and willing to fight for their privacy rights. So with that, I'm done. Thank you very much. And you guys, do you want to do questions? Yes? Okay.
Yeah, well, thank you for the presentation. But I have a very funny question probably, but it's actually very serious. On slide 3 or 4, you showed the characteristics of this Foreign Intelligence Surveillance Court.
Yes.
How do you know that this court actually exists?
So that's an interesting question. I would say one thing that I didn't have a chance to mention is that EFF recently filed a motion in that court, and we were successful. We were the very first known entity to ever be successful in the FISA court, other than the government, ever. And so we got a response from them that said that now that we've appealed to the, so it's possible that's an imaginary court, right? And that somebody else just gave us that. But it seems quite likely that that response came from the FISA courts.
Was the ruling signed by some Mr. Smith or John Doe?
I don't know how the ruling was signed. I could check on it. But it is actually the only ruling listed on their website now, or they're on their public docket. So you can go and you can see it there, and it's like the FISA court has existed for decades, and there's just this one thing that you can read.
No, but to be more serious about that, so there must be a law that describes how the judges and who the judges are and
Yeah, it's the
who
Foreign
provides a
Intelligence
budget?
Surveillance Act. It was passed in 1978.
Okay.
I might be wrong about the date. But yeah, it's the Foreign Intelligence Surveillance Act. And that was what established the court. And there's been write-ups of the court's building. They have these really thick concrete walls, these really thick doors, and they have all this biometric scanning to get into it. So it exists. I'm really confident.
Okay, first of all, thanks for the talk as well. I saw Jacob Appelbaum speak in Berlin a few days ago, and what he said was that in his eyes, if the US has informational leverage on all of the states in the world, I mean, they're spying on everyone, right? And what, in his eyes, he says that, well, they've got leverage on everyone, so the states cannot really do anything. Do you, like, would you agree with that point? Because he says, in his eyes, he thinks it's hard for Germany or any other European state to actually exert pressure on the US, because in the end, the US is the player who has the information. I mean, he does have a point, and as you already mentioned, although in the US it might seem like Germany is saying something against it, from our standpoint, it does not really appear that way. Like,
It's true. I think that it is very difficult for other countries to influence the United States policies. It is. I would say that when other countries work together, that might help. I would say another thing is the United States has a lot of particular interests that they really want other countries to do. So for example, the United States seems ridiculously interested in its intellectual property rights all over the world. So that might be an issue to negotiate around. But you know, he has a very good point in that it is difficult to influence the laws in the United States if you're not within the United States.
Yes, I had a question. So you said that the companies were protected from you suing them if they gave information to the government. They had like, what was the name of the protection again? So
that bill, that law that got passed was part of the FISA Amendments Act. So the Foreign Intelligence Surveillance Act got amended with the FISA Amendments Act. The FISA Amendments Act is what has allowed for all of this dragnet surveillance of people who aren't in the United States, and it is the instrument that provided retroactive immunity to the companies.
My actual question was if you couldn't just find out which countries have, which companies have retroactive protection, so you could just, now we know that it's every company, but back then you could have done that.
Yeah, I don't know. I think that the law probably didn't name specific companies, but said any company that assisted the government during this period of time doing this type of thing. And I'm not saying that that's something that we agree with. You know, I think that an unconstitutional law is something we continue to fight, but we just haven't made a lot of headway with that particular one.
I have just a short point. Is if you think about it, the NSA has data on us, so they can pressure us on things, on secrets we have, but if they have all the data of the other governments, they can pressure them as well. If they do anything illegal, the US government could just pressure them with the data they have. That's just my last point.
Maybe this will be the last question, and then we can...
You were first, but he's closer.
Okay. Oh, and also I have a whole bunch of EFF stickers, which I threw over here, so grab some
So,
stickers.
Clapper lied to Congress, right?
What was that?
Clapper lied to Congress?
I say capitalize the comment?
That guy lied to Congress.
Oh, yeah, Clapper.
Which is a felony.
So, interestingly, I was looking at someone else who lied to Congress, and it was like a misdemeanor. It wasn't like a huge felony. So, but it seems to me like you would. I don't know what the repercussions of it are, but I was surprised that he was still in his job. But yeah, I'm not sure what it would seem to be some sort of criminal offense, but I don't know it off the top of my head.
Being the secret court, so you only know the address of the secret court aside from the government, basically at the moment. So no U.S. citizen would be able to sue or make a case at the court
Yeah, not in
at the
the,
moment.
that's right. In the FISA court, it was very difficult for EFF to even submit our filing. And it would not be possible, I think, for the average individual to be able to maneuver it. So that is true. It's a secret court with secret rulings. One more question? Anybody? Okay, well, thank you guys for coming, and I'll be around if you want to talk.